Hello, I'm Bruce Ching. I teach legal communication and research here at Syracuse University College of Law. I'm joined today by a student, Donatello Lazzarati, who's going to help me with a demonstration on the martial art of advocacy, how to adopt martial art themes, strategy, tactics into the teaching of legal advocacy, legal persuasion, especially in the context of oral argument. The first thing I want to talk about is root. So the martial arts talk about being rooted as if you're a tree spreading your roots into the ground. Right? So what I'm going to do is have Donatello push on my chest with a slow, steady push. Okay, if I'm unrooted and he keeps pushing, keep going, all right, then I go over like this, right? Because I don't have any stability here. If I root, I should be more stable. So I'm going to have him do the same thing, okay? And this time I'm going to root so that I'm redirecting his force into the ground, okay? Keep pushing. And if I keep my weight sunk, okay, and he keeps pushing.
Go back down.
Yeah, all right, let's do that again. This time you're going to keep pushing, all right? As I sink, I root and keep pushing, all right? The force of his own push.
Take him back.
Bounces him back. Right. A break to adjust the microphone. All right, so that was root. We're also looking at the geometry of stance, which has to do with the most efficient direction in which to apply power in order to get an effect. I'm going to have Donatello stand in a stance like this, right, and hold his position as I apply some force to his stance. So if I push and he holds his position, okay, stay where you are. Right, here, good. And I really have to put some power into it in order to begin to get any movement. This is the strong direction of his stance. This is the weak direction of his stance. Right? So here, if I apply there, perpendicular to the direction of his stance, how much force did I use there?
Not much.
Okay.
Barely.
Yeah, all right. So what I'm doing is I'm listening. They call it listening, to see if I push this way, what happens, and then I change directions to achieve a big effect with a small force. The other thing is listening, right, which is very important for an advocate. Listen to the questions that you get from the judges. If we're squared off like this, see, all right, and we're in contact here, my art Tai Chi Chuan tells me listen through the point of contact. As he begins to do something, maybe coming toward me, right, I feel that and I can adjust accordingly, right. Again, come toward me here. What I'm doing is, through the sense of touch, I'm seeing where he's going, and then I redirect. If I stop listening, right, that's like if I lose contact here. At this point, then, that gives him a straight shot toward me, and I'm going to get hit. I don't want that to happen, right? So wherever he goes, I want to maintain contact. Right? One of my teachers, in terms of the Tai Chi Chuan exercises, said it's like reading Braille. Right? It's using tactile sensitivity to check the other person's position, power, direction, all of that. Now, using all of that as a base, one of the big themes that comes up over and over again is avoiding the use of force against force. Okay? If, say, he's pushing and I push back, and he happens to be stronger, like, say, he's a judge in his own courtroom, right? And he pushes at me and I push back, this is going to happen. Right? At this point, inexperienced students and practitioners tend to do the same thing all over again. He pushes, I push back, and that happens again. Okay? But there are better ways of handling this. All right? He pushes me over again, push. Okay. What happened there? Slippery slope happened there. All right. Instead of resisting his push, I added to it by pulling in the same direction that he was pushing, taking him beyond any reasonable stopping point, therefore showing him the error of his argument. Okay. So in terms of oral argument, it might go like this, very slowly. He starts to push, and maybe the question he's asking is, well, you're arguing that the trial court judge improperly admitted a witness's testimony. But don't trial courts have broad discretion in determining what evidence to admit? If I say no, that's wrong, and I'll get bounced back, right? Instead, what I do, I say, yes, they do, but in this case, right, the court abused its discretion in allowing the witness's testimony. Opposing counsel's argument implies that the trial court ruling could never be reviewed by this court, but that would be an absurd result, right? Taking the suggestion, the argument, and going with it far beyond any reasonable stopping place to show that there's something wrong with that argument. Right? Coming back. So one of the things to do is be conscious of where slippery slope arguments are available. If it's not available, but he starts to push in, but stays in his base, right, what do? I turn the corner by changing the angle that's between us, right? Come back. Again, and right there, right? Here, I'm facing him. My weapons are pointed at him. His weapons are pointed toward where I was, not to where I am now. Right? That's like his asking a question about a precedent, and I say, well, actually, Your Honor, the facts in that case were a little different from what we have here. Right? Changing the angle, turning the corner, using an indirect approach, not force against force, okay, but an indirect approach here. Aikido takes this to an extreme when it talks about seeing the world from the opponent's point of view. So if Donatello starts to come in again, slowly right there, okay, what do? I mimic his posture. I circle around behind him. At this point, I literally see what he's seeing, right? And it's difficult for him to attack my position because it's his position, right? In effect, what he would have to do is attack his own position in order to be able to attack me at this point, right? So this might be like Donatello, as judge, says, well, didn't the case of Miranda versus Arizona require that a criminal suspect be given warnings about his rights? Right? I take the concern that he's expressing, the policy underlying the rule, and I circle around and say, yes, in some circumstances, the Miranda case provided that important warnings must be given to safeguard a criminal suspect's rights. But in our case, that doesn't apply. Miranda only applies to situations of custodial interrogation. And here, the suspect was not in custody and the suspect was not interrogated. What I've done now is I've turned the argument around and I'm moving it in the direction I want to go, rather than the direction where maybe he thought he was going to push me back. Let's do it again. All right. So in application, it looks like this. Right. Again, taking the force that's given in, seeing the world literally from his point of view, the valid, legitimate policy concern that's being expressed by the court, and then distinguishing it based on the facts that we have, or maybe based on additional law that has a different sort of outcome. Every strike creates an opening. Every argument leaves the advocate maybe vulnerable to a counter argument. So why don't you come in, all right? If I'm punching down at his abdomen, what's open for him? Right, yes, he could hit my face. Right? If I'm punching at his face, what's open for him? All right, here, my abdomen and my rib cage. All right. What that means is when I'm making an argument, I'm going to anticipate where the counter argument is going to come from. And I'm going to place my response there. Right? So I'm striking high. Sorry, I'm striking low. He comes in high. My hand is already there, ready to intercept his counterattack. Right? I strike high. My hand is low, already ready to intercept his counterattack. So I have to anticipate what's going to be the response to my argument and then have a counter to the counter that's likely to come in. Related to avoiding the use of force against force, if he's striking low, say at the abdomen, okay, and he keeps coming in a little, I'm not going to try to lift this up because that's a situation of force against force, and I'm likely to lose. All right. Instead, what I'm going to do, if he's striking low, I'll take him lower, right, which opens up some vulnerabilities and takes him off balance. Conversely, if he's striking high, okay, I'm going to take his strike higher and pull him off balance there, opening up my counterattacks. In addition, an elegant result can occur if I can use one of his arguments to block another one of them. Right? If he's making an argument here, he strikes with his right arm. Okay, maybe I can intercept. That's blocked off. Now he attacks with his other arm. Right? Here, I've used one argument to block another one. Right? Although inconsistent arguments are permitted at the stage of the pleadings, it's hard to win when you're making arguments that are mutually exclusive, that contradict each other. Right? So once more, here, here, and then I can come in with the opening that's been opened up here. Right? One thing is when he's using two bases for his argument, that can be difficult for me to prevail. I'm going to bring you back a little more toward middle. All right. So he's going to stabilize himself like in the beginning. Good. Okay. What I'm going to do is I'm going to use my leg to pressure his leg, right, to take out one base, and then it becomes easier for me to push through the other one.
This is a free lesson.
All right. So here he's stable. He can switch from one leg to the other. What I'm going to do is take out one base and then push through the other one. For example, maybe there's an argument that an administrative agency made a rule that's invalid. Right? There are two arguments possible in this scene that I've set up. One is that the rule is unconstitutional. That can be really hard to argue. Another argument, though, is the rule is invalid because the agency failed to follow the notice and comment procedure required under the Administrative Procedures Act. If that's what happened, that's easy to win. Getting rid of that argument quickly indicates, well, I win. I only have to win on one of those two arguments. And if I win, I can also say, but in addition, there's also the constitutional issue, which also indicates that my side wins. Right? So the way it looks, again, is the agency's rule is invalid because it failed to follow the requirements of the Administrative Procedures Act. Moreover, there's also an aspect of unconstitutionality to the rule that it set up.
That's good.
All right. One more thing I want to point out is the combined effect of different arguments. So in the art that I practice, there's a move that comes like this, here, and then one arm up, one arm down, and the knee up. Right? If, say, he punches with his right, I'm going to take that, deflect it. Here, I'm going to elbow and come around with this arm, and then I'm going to lever the arm up, the head down, and then bring the knee up. Okay. Which is a synergistic effect. Individually, raising the arm doesn't do much. Pulling the head down, well, might do a little, and then raising the knee up to strike, it might do a little. But when all three of them are combined together, right, the effect is much greater. The damage I can inflict on him is significantly greater. So again, here, levering up, levering down, and then bringing the knee up. Thank you for watching our video. I hope that you've enjoyed seeing how martial art themes can be incorporated into legal persuasion and oral argument. And that's the martial art of advocacy. Thank you.
Okay. That was impressive.